There we go. Good. Good evening, and I want to thank you for turning out on a cool Iowa evening. This is the last session in a session that began at noon and has been wonderfully informative and wonderfully engaging series of speakers. It is my great pleasure this evening to introduce to you a man who's been a trial lawyer for more than 30 years, litigating intellectual property cases before judges and juries throughout the country, equally adept as an appellate lawyer and a prosecutor. He's well known for his eloquence and skill in patent prosecution, including appeals. He holds a degree in chemistry as well as law and graduated Order of the Coif from Drake University School of Law, where today he is an adjunct professor. At Drake and also at University of Iowa College of Law, he has taught copyright, trademark, and patent law, as well as courses in intellectual property litigation. He has, in addition, he's a member of an organization in Des Moines that purveys candies. So I have in my pocket a package of infringements from McKee, Voorhees, and Sees. And, you know, I didn't realize until somewhat recently that McKee, Voorhees, and Sees was a candy purveyor, but I understand they also do patent law as well. So I'm pleased that they have such a varied repertoire of products. He's also represented clients before U.S. Courts of Appeals and the Federal Circuit and has argued key cases before the U.S. Supreme Court, in particular a precedent-setting case that shaped the law of utility patents for plants. And as I understand it, this for a lawyer is perhaps like an opera singer singing the title role of Tosca at La Scala or singing Siegfried in Bayreuth. So we're very fortunate to have him with us today, and from him, a paper on plant patents. So with no further ado, let me invite Ed Sees. Thank you very much.
Thank you, Clark, and good evening, friends. Very familiar faces out there. I guess if I have a claim to fame, my claim to fame is that I argued the case that has created the whole issue here of the ethics of patented plants, if you will, before the United States Supreme Court back in 2001. And obviously won on the side of pro-plants. It is a great honor to get to argue at that court. To give you an idea, if you do not know, not many of the cases that go to that court go as a matter of right. They go as a matter of filing what's called a petition for a writ of certiorari. And the court decides as a discretionary matter whether or not they want to hear the case. And only they know what criteria they decide as to whether or not they're going to hear a case. It's a well-kept secret that only they and their law clerks seem to know the answer to. But to give you an idea, this court will normally hear 95 to 100 cases a year out of more than 10,000 requests to hear a case. So if they've taken certiorari on one of your cases, it means they think there's something of very important paramount interest as a matter of that needs resolution for the public interest in order to hear the case. And one of the things they will tell you if you are getting ready to argue the case at the Supreme Court, unlike every other court of appeals one ever would argue in front of, they say, don't argue the law, argue principles and philosophical points of view, the consequences of deciding one way or another. They'll know the law. So it does make the argument quite different because it's hugely motivated by public policy considerations. Anyhow, when I got into this field of the law, I mean specifically the narrower part of intellectual property that deals with plants and the patenting of plants, I didn't do it with any consideration of the ethics or the bioethics of either patenting or not patenting in this area. I did it because I happened to have a client, or more than one, that were in this area. And so since starting in that area, my clients have ranged from huge companies to universities, and one of the very most active universities in the country patenting in this area is this one. And to individuals and small seed companies, big seed companies. But believing, as most lawyers do, and as Shakespeare did, that the past is prologue to the future, let me tell you how we got to where we were in 2001 when the Supreme Court decided to take the JEM versus Pioneer Hybrid case. I represented Pioneer in that case. Before 1930, it was absolutely impossible for anyone to get a patent on a plant in this country. Why? Because the statutes didn't allow for it. Or more accurately, the statute that says what you can or cannot patent is, to the patent lawyers, is 35 U.S.C. 101, tells you 4 categories of things that are possible to patent. And if you don't fit into one of those doors, you're dead before you start. And so it's a threshold gate that you've got to go through. And those are machines, articles of manufacture, compositions of matter, processes, and improvements in those. Well, where does a plant fit? In theory, a plant could fit into a couple of them, article of manufacture or a composition of matter. But the problem was, and why the patent office wouldn't ever allow regular utility patents like they do on machines to plants, is to get that patent, you must write an enabling written description in order to describe no one could meet the written description requirement of the statute for a plant. Well, there was much agitation and dissatisfaction with this state of affairs, beginning particularly in the late 20s and the early 30s, to the point quote. All right, thank you. No one has advanced a just and logical reason why reward for service to the public should be extended to the inventor of a mechanical toy and denied to the genius of whose patience, foresight, and effort have given a valuable new variety of fruit or other plant to mankind. They were arguing about the discrimination against inventors of particular kinds of things, i.e. plant breeders. And interestingly enough, as a bit of a side, even as late as the time that I became a patent attorney, which is in the late 1960s, biologists could not qualify to take the patent bar exam. So you could not become a, quote, patent attorney if your background was biology. So that's how far we have come. Well, with testimony of powerful breeders like Luther Burbank, famous inventors like Thomas Edison, in 1930 we passed a statute that allowed some limited plant protection called the Plant Patent Act of 1930. Not very creative in title, but that's what it was. It, however, was very limited compared to what we have now today, and it only applied to asexually reproduced plants. Anything that was a result of sexual reproduction could not be, therefore, patented. Why did they limit it to asexually reproduced? The theory at the time was if it's asexually reproduced, like by tuber propagation or grafting, you know for certain you've got the same thing that you started with. And so the possibility of natural genetic variation didn't exist in that circumstance. And so stability and uniformity were a certain thing. Well, that worked for people that did things such as apples, but it didn't work very well for particularly cash crops like row crops, corn, soybeans. And why? Because they're sexually reproduced plants, and so you couldn't get any meaningful protection. The problem perhaps was a less of a critical with regard to corn than it was with regard to Iowa's other major cash crop, soybeans. And why is that? Well, everybody plants corn as a hybrid, meaning that it's a cross between two inbred plants. And hybrid, Henry Wallace founded Pioneer on that basis, our former vice president. And hybrid seed, you can't save the seed at the end of the season, replant the following year and the following year, and come up with the same vigorous, high-yielding crop. Why? Because a hybrid begins to segregate after the second planting, and it gets worse and worse, and the crop and the yield go down and down. And so it's a perfect crop for proprietary protection other than patents, if you will, trade secrets, for example. But take a varietal crop like soybeans. There's no commercially available significant, as far as I'm aware, soybean hybrid. Why? It's because on the soybean plant, the male part of the plant and the female part of the plant are almost touching. They're virtually right next to each other. Compare that with corn, where you got the tassels way up here and you got the silks way down here. There's a long ways in between. There's a lot of room for random cross-pollination. Not so with soybeans. And so soybeans, because of the very close physical nature of the male and the female part, are going to produce an inbred plant year after year after year, which means what? Which means the genetics never change. So whatever genetics you put in that plant, if you save seed and plant it the next year, it's going to be the same. If you plant it the next year, it's going to be the same. If you plant it the next year, it's going to be the same. And that's why people like Percy Smizer can literally steal from Monsanto. And that's what he did. I mean, you call it what it is. He stole. His argument of pollen drift was a red herring. There was no pollen drift. And that's why the court, so to speak, excuse my French, but nailed him. Because he lied. He said it was pollen drift. It was regularly planted, saved seed that had the genetics of Monsanto in it. And it was planted in regular patterns year after year. There was no pollen drift in it. And the court recognized that. And so, anyhow, the possibility then for some sort of protection still cried out after the 1930 Patent Act, satisfied some fruit, some vegetable people, but no one else. 40 more years go by to 1970, and Congress passes a statute to try to alleviate the building stress called the Plant Variety Protection Act of 1970. Now, this does give more limited but nevertheless protection, not akin to a regular utility patent like Thomas Edison got on his light bulb, but it provides a certificate of registration for new, distinct, uniform, and stable plants. New, distinct, uniform, and stable. Those are the four requirements. Notice that they want distinct, uniform, and stable. They want predictability. They want certainty that you're going to get what you say you get. Well, why weren't seed companies, not only everybody always talks either of Monsanto or Pioneer, but there are many others, why weren't they satisfied with the Plant Variety Protection Act? It is because the scope of coverage, the protection that was available, was more akin to what we would call a copyright, we who are in the business of this. It basically protected from copying or cloning, but nothing else. And as far as the seed industry was concerned, it had two massive holes in that statute that almost guaranteed public free rides for anyone who wanted to be less than scrupulous. What are they? It's the saved seed exemption, and it's the research exemption. If you get Plant Variety Protection Act certificates, anyone has the right to save seed and plant another crop to the extent they buy seed from you for 1 year. And there is a research exemption that allows anybody to do research with the seed, covered seed, without any liability. Now, large commercial enterprises, like a Monsanto, like a Pioneer, like a Syngenta, like a, I'm trying to think of the name of starts with an S, a vegetable company. It's not semen, but it's something like that. What is it? Yeah. This is just not satisfactory to them when they spend millions of dollars. Remember, the problem is that you're dealing with a property right here in something that has a built-in Xerox machine in it. I mean, turn it on, nourish it, trigger it, and it can copy itself. And so it creates huge intellectual property challenges that our court system has never had to deal with before, and that American research industry has not ever really had to deal with before. Well, the breakthrough that eventually led to the JAM Pioneer case came in 1980 in the Chakrabarty case that went to the United States Supreme Court. It did not deal with plants. It dealt with microorganisms that were genetically altered in order to allow the organism to eat oil spills. I'd say, boy, this is good. Eat them all up. And Dr. Chakrabarty inserted a particular gene sequence into the microbe that would allow it to do that where it otherwise would not do it before. I often wondered on the history of that, well, why didn't they use that in the Gulf? Or why didn't they use that in Exxon Valdez oil spill? 3 or 4 years ago, actually it was 2010. I was at a conference where I was one of the speakers, and Dr. Chakrabarty, still alive, was one of the speakers. And they were celebrating the 30th anniversary of that case. And I asked him, well, why didn't they use your bugs in the Gulf? And he said, well, the truth is they worked, but they didn't really work great. And secondly, no one was quite sure what would happen if you massively released these things, for example, in the Gulf of Mexico. And so they potentially could be creating an environmental problem bigger than the problem they already were faced with. And so for that reason, they were never used. Well, in the Chakrabarty case, now deceased Chief Justice Berger wrote the opinion. The court dealt with a slightly different issue than we're dealing with here. The issue was whether or not the microorganism could be patented because it was living. This was a living microbe. The argument against it was, well, look, we have 2 other statutes that Congress specifically passed that deal with things that are alive. One is the Plant Patent Act, remember, that covers asexually reproduced plants. and the other one is administered by the Department of Agriculture, the Plant Variety Protection Act. If we could already get patents on living things, so the argument goes, why in the world would we need to have passed those specific statutes? That must show Congress's intent that they didn't think the original patent law covered living organisms. And it's not a bad argument. In fact, I think it's a fairly decent argument. But the Supreme Court concluded that it doesn't matter whether something is living or not as to whether it meets the test for patentability. Why? Because if you look at 35 U.S.C. 101, the threshold door that you got to go through meet one of those four categories. Is it a machine? Is it an article manufacturer? Is it a composition of matter? What's the other one? Is it a process? It doesn't say anything in that statute. Incidentally, you know who drafted that statute? Thomas Jefferson, 1790. It's remained essentially unchanged since then. It doesn't say anything about whether the thing is living or not. And so the court concluded that the property of life is an irrelevant issue in determining patentability. And that opened the door. And we have had dramatic change in all respects since that day. In 1985, on its own, without any pushing from anyone, the Patent and Trademark Office decided that the decision in Chakrabarty, if properly read, should allow the issuance of patents on plants. And so they changed their policy overnight. In a little-known Board of Appeals decision called Ex parte Hibbard, and said, I'm paraphrasing, and it doesn't say it this way, but this is the message that comes to the bar. Fellows, we're changing. Tomorrow you can get patents on plants, regular utility patents, the same kind that Thomas Edison got, the same kind that Alexander Graham Bell got. You're not confined necessarily to asexually reproduced plants, nor do you have to necessarily get Plant Variety Protection Act certificates if you don't want to. Now, they made it abundantly clear in that little decision from the Board of Appeals, you still got to meet the other criteria for patentability: new, useful, and non-obvious. And you have to meet the written description requirement of Section 112 in order to write your invention up properly in order to get it. Well, the seed industry enjoyed that and used it heavily from 1985 until the JEM Ag Supply case came along. Everyone knew there was lurking in the background an issue of really this kind of fundamental change coming from the Patent Office Board of Appeals. But the problem was no one ever challenged the underlying patentability, because you had basically seed companies fighting seed companies, and no one wanted to make that argument because they didn't want to kill the goose that laid the golden egg for all of them. And so it was just an underlying argument that was there. But it took a case like the JEM versus Pioneer case, where the defendant is not a seed company at all, but a wholesaler, a black bag wholesaler that's illegitimately selling patented seed, who doesn't care what the final result is, doesn't care what the impact or negative impact might be on the seed industry. And so when they got sued by Pioneer on 17 different patents, now these are not genetically, they were all for corn. They were not genetically modified organism patents. They were patents that resulted from traditional Mendelian genetics plant breeding, a painstaking step-by-step thing. And they related primarily to properties such as increased stay-green power, stalk stiffness. You want good stiff stalks so when the heavy corn comes in the fall, they don't blow over in the wind and lay on the ground and things rot before harvest. and you need good root lodging, i.e. really attached to the ground. Those are very desirable things for a corn plant. Most of these patents related to one of those three properties. The defendant, when I read the defendant's answer in the lawsuit, I almost didn't think he filed a legally recognizable answer, because he did not attack the patents on any traditional grounds of invalidity. He didn't challenge the novelty of the inventions. They didn't challenge the utility of the inventions. They didn't challenge the obviousness. What they challenged was that it was not statutory subject matter, because it didn't fit into one of the four pigeonholes, and that since 1985, the Patent Office had it wrong. They've been issuing over 2,000 at that time, over 2,000 patents on plants incorrectly as an ultra vires act without authority. And that was their position. And that's what got us to the Supreme Court in that case. Judge O'Brien in the Northern District of Iowa had the case and decided that, on summary judgment, that while it was an interesting argument that the defendant was making, he recognized that it was going to turn the Patent Office's 15-year practice on its head, and declined and concluded that utility patents really are proper subject matter for plants, and cited Chakrabarty on the issue of living. And with respect to this defendant, now they argued a slightly different argument than Chakrabarty. They argued this is a much closer case than Chakrabarty. Why? Because we're talking about plants here. Chakrabarty was talking about microorganisms. And plants, we already know Congress has looked at, and they've given you two other regimes to deal with. The Plant Patent Act of 1930, and if you don't like that, the Plant Variety Protection Act of 1970. And the argument here is, if they thought you could get a regular utility patent, why in the world did they pass those specific statutory regimes? The counter to that is, well, there's nothing wrong with dual regimes of protection. It's recognized in the overlap between trademark and copyright on occasions. It's recognized in the design patent and copyright area on occasions. And if you can meet the criteria of the statute for each of them, you're entitled to each kind of protection. That's the counter argument. That's our side of the case. Well, when it went to the Supreme Court and they decided and cited the now famous language from the Chakrabarty decision that one must interpret 35 U.S.C. 101, the threshold opening the door gate, broadly. Why? Because the language originally used by Thomas Jefferson in 1790 was broad. It's virtually not been amended since, and that language has to be broad enough to cover both foreseen and unforeseen inventions of the future. As I argued before the court, today's science fiction can be, and often is, tomorrow's science. So the statute needs to be interpreted broadly in order to cover unforeseen technologies. And they cited the famous language from Chakrabarty, anything under the sun made by man. I remember one of the other speakers earlier today said that's a bit of a stretch as to what the legislative history shows. But the language is great, and they said it supports the Supreme Court's view, and after all, if the Supreme Court said it, they have the right to decide it's the law. So it is the law. And so since 2001, it's been settled law in this country that regular utility patents can be granted for plants that otherwise meet the statutory criteria, importantly, that are derived from conventional breeding genetics. We're not necessarily talking about GMOs. The United States and Canada stand singularly alone in that position. The rest of the world doesn't go there. Much of the rest of the world will recognize genetically altered plants if you can use the genetically altered insert in more than one variety. And so to the rest of the world, the U.S. has gone, and Canada, have gone kind of crazy. The U.S. and Canada obviously think they're right. And whether you believe that the U.S. and Canada are right, or whether you believe the rest of the world, and it varies all over the place in the rest of the world, are right, sort of depends upon your philosophical points of view. If you believe that the people that do the hard work, that roll up their sleeves and make something happen, and that make the investment should reap the reward, then you're in favor of what the U.S. does and what Canada does. You cannot develop, for example, a corn hybrid. I used to know the exact numbers. I know this number is right. $7 million, I think that is to develop an inbred on average. It takes 2 inbreds to make a hybrid, so there's $15 million of investment in any good hybrid, for example. Now, is it fair to allow a free ride on that once that's put in the field? Or should the person that made the investment reap the benefit for a limited period of time? Well, it's foolish to argue that in this country or in Canada. It's the law. And our forefathers already decided that it's a good thing when they passed Article 1, Section 8, Clause 8 in our Constitution, establishing our patent system to incentivize full disclosure in return for a limited reward. I mean, that's a done deal. That happened back when we had our Constitution. And so unless we change the Constitution, it's very unlikely that that's going to change in this country. So complain as you like about it. If you don't agree with it, in the U.S., you have to live with it and you have to work with it. And I don't ever much think, frankly, as the lawyer that's representing the client, whether the bioethics of it seem irrelevant to me, because they're irrelevant to the judicial decision that's going to be made by a judge or a jury. You don't argue bioethics to them. You argue what the current state of the law is, that this is the current state of the law. Well, is it good? I can tell you this. Look at what happened. Look at what has happened to the major seed companies of the world, headquartered in the U.S. since 1980. They have exploded in terms of growth, in terms of number of jobs, in terms of what's patented, and in terms of the benefits that we as members of the public realize from the traits they've put in these plants that never would have been put in without the huge incentive of patenting. For example, some of the speakers earlier today talked about wild rice and the issues with Native Americans on wild rice, whether we should be allowed to genetically alter wild rice. Well, you are allowed to. You can do it right now. File a patent application on it if you want. But is it wrong? Well, I'll tell you, if we hadn't done something to corn, the first corn plants were found in Mexico, and corn is really a grass, and it was found in Mexico back in, they have it recorded, actually found cobs, and the original cobs on corn are about that big. So compare a corn cob of that size, which was wild corn as a grass in Mexico in 1400, compared to what we now have, and you'll see what responsible use of genetics has done. One statistic that I found rather interesting as I was looking up a few statistical things to give you tonight. Think about this. If we had not done what we have done to corn and soybeans in order to increase yield since 1930, in order to satisfy the need for corn and soybeans in the United States, we would need more land greater than the size of Texas right now in our country. And so, certainly, good has come from these inventions that have resulted from allowing patents in this area of plants. More jobs, improved yields, crops that don't pollute as much. By that I mean they need less herbicide, less insecticide, new traits put in plants that never before existed. Frost-free tomatoes, for example. There are even plants that express vaccines. They grow the plant and expresses the protein and extract the protein and you have a vaccine. Things that could not possibly have been foreseen, and things that represent protectable technology that was impossible to protect before. I'm told that the genetic yield of both corn and soybeans have increased by more than 50% from where it was in 1930. I can't swear to you that that's true, but I've been told that that's true, and I have no reason to disbelieve it. It's good, I suppose and expect, that in universities you debate these issues and the bioethics of the issues and the philosophical points of view of what's right and wrong. But I ask you to have some sympathy for the courts that are deciding these cases, because they don't have the opportunity to debate ethics. In every case that comes before them, whether it's one of the greatest soybean breeders of all time is your own Dr. Fair from here, whether it's Dr. Fair as an individual that comes before the court, or whether it's a Pioneer or a Monsanto, one thing that you know is by the time that court decision is over with, somebody's going to be right and somebody's going to be wrong, because the court system is designed to figure out who prevails, who's right and who's wrong, within the framework of the rules that our Congress sets up for them to operate under. And so it is an ever-changing system. There are times when the courts make changes on their own by interpreting the statutes that they feel are needed. There are times when Congress makes the dramatic changes when they feel they are needed, like the 1970 Plant Variety Protection Act and 1930 Act. There are times when the court steps in, as the Supreme Court did in Chakrabarty, as the Supreme Court did in JEM. I think the true answer is be patient and watch and see how it works out. For example, there's much discussion about species contamination, about pollen drift and the undesirability of it, and the fears of strict liability because there's pollen drift and you're accidentally growing an infringing plant. I don't know this, but I suspect if you had a true case of accidental infringement because of pollen drift, and the court were convinced that it was truly that, and not someone lying to it, like I argue Percy Schmeiser did in the Canadian court system, I would guess the court would figure out a way to not hold any liability under that, perhaps under some doctrine of accidental infringement, which I think does exist in some foreign country patent laws, but at this point, not in the U.S. patent law. And so Law is supposed to be moving slowly compared to society and take steps like a tortoise or a turtle. After all, Watson and Crick unraveled DNA in 1953. It took the Supreme Court 27 years later before they finally decided you could patent living organisms. And so we're on a path that is never-ending and highly interesting, with issues today that the courts have never had to face before, such as so-called accidental infringement. And I'm confident the system will be able to handle it, and everybody, for the most part, will be pleased with the result. I want to mention one more thing, and that is one of the speakers today said, interestingly, as an anecdote, and then let it hang and drop, that in the JEM versus Pioneer hybrid seed corn case, the decision was written by Clarence Thomas, who just incidentally happened to be a former Monsanto attorney. And I've seen published in literature arguments, suspicious arguments, that perhaps Monsanto, Pioneer, and all the rest of them were in some sort of cahoots, if you will, to get this case before the court and to get this case in front of Clarence Thomas. Well, if you know anything about Pioneer and Monsanto, I mean, they hate each other. There's no love lost between those two companies. It's like Ford and Chrysler. You know, they're arch-rival competitors. I assume there's some respect, but I guarantee you there's no collusion between the two of them. And incidentally, I asked Clarence Thomas. He was a adjunct professor for a week at Drake, and I have the original slip opinion that the court when they hand down an opinion, there's an original slip opinion that comes down from the court, and I saved it, and I asked him to sign it for me when he was at Drake, and he did that. And someone else asked him, not me, but I listened, said, how is it that you happened to write that decision? And he said, the chief, and that would be Rehnquist, he said, the chief assigned it to me because he knew I was the only one that knew anything about corn. So, and I suspect that's the truth. You know, I suspect that's the truth. So, anyhow, that's probably more time than I should have taken, so we'll open it up for any questions that people might have.
Is this working? Oh, good. Well, thank you so much. I am going to take the moderator's privilege of asking the first question, but I want to invite everyone to, you are certainly welcome to come up and pose questions here. So I have a somewhat longish question, and I want to apologize for that in advance. But there is a model of judicial decision-making and court decision-making which used to be called mechanical jurisprudence, according to which courts really don't have much leeway. And once a court is posed a problem, the reasoning of the court needs to follow directly statute, facts, and decision. I think among people who look carefully at court decisions, that view is defunct. I don't think that view accurately describes what actually happens in courts. And I'm wondering, because it seemed to me in several respects the way you're describing court decisions looks like that. And I want to use the Schmeiser case, and I want to use a couple of other cases that are relevant to just to call that into question. One of the things that you mentioned was that in arguing before the Supreme Court, you said you shouldn't argue the law, right? Instead, you should argue the philosophical principles that lie behind the law.
Or policy.
No, or the policy, right. And it does seem to me that as I read Supreme Court cases, I do see the justices looking at issues of policy. I mean, I see them carefully thinking about the implications that their case will have, that alternate decisions would have for people and for the disposition of subsequent law. Now, in the Schmeiser case, I don't want to argue the facts of that case. I may agree with you substantially about the behavior of the character, but what most people who have heard of that case know about it is that it's a case where a farmer was held responsible for pollen drift. Now, maybe the Schmeiser case isn't accurately that case, but it seems to me that the question, can one be held responsible for pollen drift, is still, to some extent, an open question in U.S. law. That is, sorry, I don't know if you've heard me, but it seems to me that what that means is that the courts really are thinking about the ethical issues and the policy issues that sit behind the law, and not merely deducing the outcome of law from the statutes as they're given. And thank you. I'll sit down and accept your response.
Is that a question?
Well, I take it to be a challenge, because if what I'm saying is true, then it would challenge what you're saying.
It wasn't me that said you shouldn't argue the law at the Supreme Court, argue policy and consequences of results. They say it right in a handbook that they give to practitioners who are going to argue before the Supreme Court. And in fact, I practiced with a young man who used to get ready for that. His name is Richard Taranto. He clerked for Sandra Day O'Connor. And he basically said the same thing, you know. And so a little story behind that. The very first thing out of my mouth, because I argued it at the Court of Appeals, one step below the Supreme Court, I argued the Chevron deference principle. Now, no one here knows what that means, but I'll tell you in a sentence. Chevron deference principle means that if a court that is specialized and hears something and hears it on a regular basis, gives a decision in the area that they have experience in, any reviewing court should give deference to that. That's the Chevron deference principle. And so the first practice round I went through with Richard, remember this is Senator Day O'Connor's clerk, he said, oh my God, no, don't argue the Chevron deference principle. I got up there, and so help me God, about the third question, Justice Ginsburg said, Mr. Cease, I noticed that you won at the Court of Appeals. And I said, yes. And she said, that's a specialized Court of Appeals, isn't it? And I said, yes. And she said, why doesn't the Chevron deference principle just take care of the case? So every rule is broken. Now, I guess what I would say in response to you, a hard and fast rule that sounds absolutely mechanical if you've got true pollen drift and there is no intent on the part of the adjoining landowner to do anything wrong or perhaps even any knowledge that it has happened. Strictly speaking, they may be an infringer, because the statute says you can exclude others from making, using, or selling. And arguably that person, maybe unknowingly, but they're certainly using, and they're making. I say to you, I am confident that it would happen at a district court level, probably not at even the Court of Appeals level. If that truly was the case, a court is going to look at the equities of the situation and figure out a way to relieve that potential defendant of liability under some doctrine of accidental infringement or something. Because, you know, if there's anything that our federal judges, and these are all federal cases, are trained in, it's trained in making difficult decisions that require them to balance equities on both sides and somehow reach a fair and just result. And I'm confident that that would happen. And I don't know if I've answered your question, but
I just want to say, I mean, I'm confident that that would happen too, but I think it's the fact that that's what would take place reflects the fact that the courts really do have access to ethical considerations and considerations of what, you know, what a just result ought to be in that case, so that when the law is uncertain or unsettled, it's available to them to think about the very sorts of issues that are on the table at this seminar.
you know, if you don't like what a judge does, he's an activist judge. If you like what he does, he's a brilliant jurist. So it's all in names, I guess. Let me just say to you that I'm surprised how many of you hung in here for this late hour, for this go-around. If these issues are really something that are truly interesting to you, I would highly recommend this book to you. It's edited by Jay Keeson, who's a law professor at the University of Illinois. He's jointly appointed at the University of Illinois Ag School and their law school. It's called Agricultural Biotechnology and Intellectual Property, Seeds of Change. And most everything that's been going on all day long today is addressed in a fairly scholarly way here. And if you are really into economics and economic theory and economic impact and statistically significant studies of that, some of that's in here, far beyond my understanding of the high-level mathematics of it, I might add. But I'm not the scientist, but many of you are. Any other questions?
Hello. If you say the judges shouldn't have ethics, when you decided to kind of take on the case, I guess, did ethics play a part in your decision to take it,
No.
or did you just do it because it was part of your job?
I didn't even consider ethics. To a practicing lawyer who represents clients day in and day out, ethics means your ethical responsibility under the Code of Ethics for lawyers. And as long as you are acting under the Code of Ethics in a responsible, professional way as a lawyer, whether you personally believe in the position that you are espousing for your client or not, for most lawyers is not the determining thing as to whether you will get involved in the case. And it never even entered my head in this case. Now, maybe you say I'm crazy, it should have, but it didn't. Yes, sir.
I have a friend who's a farmer here in Iowa, was the president of a national farm organization. Him and several other farmers and other people sued Monsanto regarding patent. I don't know the details of the case. I can't remember it all, but he knew about it, and he told a group of farmers about it. They sued, and it went to federal court in the state of New York. The judge dismissed the case. Later, they found out the judge had worked for Monsanto. How can such a thing happen? How could he even be allowed to rule on such a case?
Well, a state court case or a federal court case, do you know?
I'm sure it was a federal case.
Whether I mean, the answer is I don't know enough facts to really know, but I suspect that the legal propriety of that judge hearing that case would depend upon how long ago he worked for Monsanto. If it was a year ago...
What do you mean? Anytime he worked for Monsanto, that makes the difference.
No, not necessarily. I don't agree with you.
It shouldn't be like, well, 2 years ago, 5 years ago, 10 years ago. Well, he worked for Monsanto at one time or another. He had a vested interest in seeing what happens to Monsanto.
Not necessarily. I'll give you an example, sir. I worked for Procter & Gamble Company for 7 years as an attorney. It ended in 1973. Procter & Gamble Company is today as much a stranger to me as it is to most anyone that's sitting here. I don't know anything about it. It's so long ago, it's ancient history. If I were a sitting judge, I would have no problem sitting on a case that Procter & Gamble was involved in.
Well, at this point, if there are no further questions, I would like to call us to an end. Thank you so much.
Thank you.
Professor Sees. Really appreciate it. There are refreshments at the back of the room, and we can reconvene and continue discussion. So thank you for coming, and